What is a deposition? A deposition, in layman's terms, it can be described as a question and answer session. It's essentially when the attorneys, the parties, and a court reporter gather in a conference room not unlike this. In fact, we do hold some depositions in the very room where I am now. It's a chance for the other side to essentially ask a plaintiff questions, and conversely, a chance for the plaintiff attorney to ask the defendant or the defendant's representative questions. It is a rather informal process, but it is an extremely important part of the process, maybe other than the trial itself, the most important part of the process. Because a little booklet called a transcript will be created. Everything that the attorneys say will be in that transcript, everything that the parties say will be in that transcript. And that transcript will never change. That transcript will be a part of the case right up until the very end when the case goes to trial. So it's important that the parties that are testifying and the attorneys understand that what is said at the very beginning of the case needs to be said at the deposition, and what ultimately will be said at the deposition will be said at trial. The topics that will be covered during deposition will include general background information about the person. Certainly they will touch on the incident that brings everybody into the deposition. They will discuss the injuries. They will discuss the treatment that the person has endured to address those injuries. Also addressed will be how the person is doing now, and importantly, how they were doing before the incident occurred. And I tell my clients that there are really two purposes to a deposition. First, it's to discover information. Just like we are allowed to ask depositions of a defendant and a defendant's representatives to prepare our client's case for trial, the defendants are allowed to ask our clients questions so that they can prepare their case for trial. The other purpose of a deposition is to evaluate the person, the plaintiff, and the case to determine whether they want to settle the case or they want to proceed to trial. So it's very important that our clients understand that the deposition is very important. After that deposition, the attorney that has taken our client's deposition will then have a conversation with the adjuster. Some people may feel as though it's the attorney who has the authority to settle cases. That's not true. It's in fact the insurance company and the insurance adjuster who has that authority. So certainly adjusters are going to want to know about the incident, the injuries, and the treatment, but primarily they're going to want to know, are our clients credible? Is what they're saying, does it ring true? Will a jury believe our client? Secondly, they're going to want to know if our client is likable. Human nature is what it is. If the case does go to trial and the jury's on the fence on any issue and they have to make that determination, who they believe and who they like is very important, and one of the, if not the first impression that the attorney and the insurance company is going to get about our client's credibility and likability will be at deposition.